Yes, sir, we are live now. Good afternoon, participants. Welcome to the live session of the course Hindu Personal Law, including Marriage and Succession. Our instructor, Dr. Anoop Kumar sir, is here with us. Kindly join in and feel free to ask your doubts. Over to you, sir.
In meantime, I want to go with the questions which is already posted by the student.
Yes, sir.
The first question is, how does the application of Hindu law differ between the rural and urban context in India today? This question is not relevant at all. Why not relevant at all? Because application of Hindu law not dependent on the rural or urban area. Hindu law applied within India, and application of Hindu law dependent on the identification of parties, whether party are Hindu or not. Therefore, in broader term, application of Hindu law may be explained either from the perspective of territory or the perspective of person. Territory means a person who residing in India, Hindu law will apply on them. In India, maybe rural or maybe urban. Hindu law may also apply outside India. In which circumstances? When parties are domiciled Indian, but they are living outside the territory of India. Because they are Indian, therefore Hindu law will apply on them. And if a person is Hindu as per section 2 of Hindu Marriage Act, then Hindu law will apply. Hindu law is lex fori law, means law forum, not law of locality. So therefore, the point is very clear and simple. That is, have no relation with the rural and urban differentiation. Hindu law will apply as it is. Either you are residing in urban area or rural areas. This is the first question. Now, next Bharati post number of question. The first question regarding the between Shruti, Smriti and customs, which have been most influential in shaping the modern Hindu law. This question is substantially important. Although Smritis are based on Shruti, Shruti is fundamental. But the fundamental question is, which influencing more? In that context, Smriti and custom both influencing more in comparison to Shruti in development of modern Hindu law. For example, if I go with the idea of Smriti and its impact on development of Hindu law, the point is very clear and simple. The number of provision of Yagyavalk and Manu Smriti is still applicable under Hindu Marriage Act and Succession Act. It is very clear. Hindu marriage is sacrament. Why it is sacrament? Because of Shruti. Simultaneously, custom is also recognized by law properly. For example, marriage must not be solemnized between Sapinda relatives. This is also prescribed by the Shruti as well as by the custom. Therefore, in modern law, it is also recognized as a condition of marriage under section 5, subclass 5 of Hindu Marriage Act. And simultaneously, Hindu marriage must be solemnized. And where there is a Saptapadi, marriage considered complete and binding at the 7th step taken by the parties. In that context also, it may be concluded that this is the implication of custom. If we are going to analyze the provision of section 5 subclass 4 and 5, 4 and 5 are subject to custom. If custom allow, you may not follow the section 5 subclass 4 and subclass 5. Age of adoption is less than 15, but adoption is possible after the 15-year age if custom allowed. Married man cannot be adopted, but custom allowed, it may be adopted. So therefore, Hindu law is a codified law which is based on the practice of Shastra as well as customary practices of the people. No one can draw a line that the custom or Shruti, which is more influential. Both are influential. And the better point is custom followed what Shruti suggested, what Smriti suggested. What Smriti prescribed become the custom. Custom is accommodated by this provisions of Hindu law. This is, I hope, the answer of the first question of Bharti. Second, how do courts today view custom that contradict codified Hindu law, especially in marriage or succession cases? Friends, point is clear and simple. Section 4, subclass A, either of Marriage Act or a Succession Act, have a clear provision. Any text, interpretation, or any custom shall cease to have effect if something provided in the act expressly, means custom is there, law is there. If law is clear, custom will considered wide. But law itself open scope for the custom. If there is a contradiction between law and custom, obviously law will prevail, no problem. But where law allowed the custom, for example, Section 7 of Hindu Marriage Act, marriage may be solemnized as per the customary rites and ceremony of either party of marriage. They are free. It will be decided by the custom. What is the ceremony of marriage? For example, how you can perform Saptapadi. But point is, under Section 4 subclass A, for which the provision is not made under this act, in these circumstances, custom will prevail, Shruti will prevail, Shastric Hindu law will prevail. For example, what is the marital obligation of husband and wife both together each other? It is never prescribed in the act. Therefore, in this regard, custom will prevail and Shastra will prevail. As such, there is no contradiction. If there is a contradiction, law will prevail over the custom. But where law open scope for the custom, obviously custom will prevail. For example, Section 29 of Hindu Marriage Act, which recognized customary divorce. General rule of divorce is possible only by the judicial pronouncement. The exception is if the custom is prevailing between the parties, then through the custom, marriage may also be dissolved. Section 29 is saving clause. So where custom will prevail. So there is a contradiction, law will prevail, but where a scope of custom is there, then custom will prevail. Where custom will prevail under Hindu Marriage Act, Section 5 subclass 4 prohibited degree law, but custom will prevail. Section 5 subclass 5 Sapinda relationship, but custom will prevail. Section 29 custom will prevail. Adoption Section 10, adoption must not be after 15 years, but custom will prevail, may be possible. Adoption of married person, custom will prevail. So this is the rule. On that basis, we are able to explain the entire discourse. This is the answer of the second question. I hope it is clear. Now the third is the Mitakshara and Vaibhag school interpret the inheritance differently. How do these differences still affect family dispute today? Mitakshara developed the idea of Kopasnari, where the Mitakshara talks about the by birth right in the ancestral property. Therefore, the family which governed by the Mitakshara law, son have no right in the self-acquired property of the father, but son have by birth right in the ancestral property of the father. This is the point. In that context, the principle of Mitakshara law influencing today our legal practices. Because Section 6 of Hindu Marriage Succession Act is also very crucial, which talks about the dissolution of the property in Kopasnari. Kopasnari, because of custom, because of the Mitakshara. What the reality today is, both the principle of Mitakshara and Daibhag is now applicable in the Hindu law. Although they are different, but areas are also different. So therefore, where Mitakshara will prevail, parties will proceed through Mitakshara, and where Daibhag will prevail, party will proceed with Daibhag. And still, we have a by birthright. Grandson is also having by birthright. Why? Because of Mitakshara. Why father's name is reflected in the second class heir? Because of Mitakshara. Although it is codified, spirit of Mitakshara is codified. So therefore, the role of understanding the difference to understand the law properly. This is the point. On that basis, we are able to explain the difference between these two. Now, the next question is, what are the practical difficulties in obtaining divorce by mutual consent under Section 13B, especially regarding the cooling off period? There is no such difficulty. Section 13 capital B especially talks about the cooling period. Initial idea is that parties should think before the drastic step, because divorce may dissolve the marriage. Therefore, please wait. Cooling period have a purpose. They should spend some time, try to resolve their conflict. If they are not, then they proceed towards mutual consent. No problem is there. But now the law is very clear and simple. Supreme Court finally concluded that Section 13 capital B cooling period is not mandatory. The court may dilute this requirement. Why? Because if the number of things is settled, suppose alimony is clear, maintenance is clear, guardianship of child is clear, who will take care of the children is also clear, then court is not going to wait for the cooling period. Suppose both the parties are living together separately, 5 years, more than 5 years, why they will be there? This is the point. So there is no as such difficulty. Purpose is very clear, is that you should rethink, because marriage is holy, marriage is required for family institution. Marriage may serve the purpose to transform the life of children, and everything will be affected after the divorce. Therefore, if you are going to divorce, kindly rethink over that. And in this context, this idea is very clear and simple. We should think like that. There is no such problem, but purpose is different. And as per the Ashok Hurra case, the point is very simple and clear, that it may be diluted if certain conditions are fulfilled. It is fine, I hope. The next one raised by the Jasprit. In devolution under Section 6, what happened when there is a clash between the survivalship right and testamentary succession? How do court handle the dispute with a religious custom of inheritance contradict the codified Succession Act. There is no such difficulties. Problem is very clear and simple. Section 30 authorized Hindu male to make a will. Now the question is, what is your limit to make a will? Your limit to make a will dependent on your right. For example, if you are co-partner, you have interest in co-partner property. If you want to writing a will, kindly separate your property first and then will. Or if you are not separating, then you are eligible only to provide property to another person through will up to the extent of the share in the property. Suppose property is 1, you also have a son is owning 50% share, you are owning 50% share. Testamentary succession will permit you only will up to 50%. And if you will, no problem. If not will, property will devolve as per the survivalship and your son will inherit everything. The law is very clear. Inheritance means transfer by the operation of the law. Testamentary or will means transfer of property by the act of party. You wish, then you transfer. Transfer of property. Will. Both are different. You first decide whether the property is paternal or ancestral. If the property is paternal, nothing survivalship provisions will apply in this case. If the property is ancestral, then section 6 will apply. Therefore, you are bound to dissolve the property within your heir. But under section 6 also, up to the extent of your share, you have a right to devolve your property. So there is no such kind of difference and no dispute, and the court may handle by identifying the nature of property. Self-acquired property, you have 100% right, no problem. In ancestral property, you have right up to the extent of your share only. This is the practice and this is the law. Therefore, court may easily decide what will happen in certain circumstances. I hope this is the appropriate answer of this question. Any other question, please?
Not with you. Any other questions, sir? I'll just check on the YouTube. Just a second, sir. On YouTube, nobody is watching the event, sir. And thank you so much, sir, for answering the queries raised by the students via Google form in a very clear and concise manner. Can we wait for 2 more minutes, sir? Just in case if somebody joins in.
Oh, yes, we can.
Sure, sir. So other than these questions, would you like to discuss anything in general, sir, related to our course?
Yes, I can discuss if you allow me.
Yeah, please go ahead, sir, then.
I want to discuss something not because we have time. We should think when we are thinking about Hindu personal law. Hindu personal law is codified law. What was applied in India prior to the independence was compiled by the legislature and produced by the legislature for the purpose of the Hindus. Now the fundamental question is, if the law is codified law, how we can explain, how we can understand, how we can interpret this Hindu law? This is the fundamental question. Because family law is regulating the day-to-day affair of Hindus, and therefore no one can say that it may be interpreted on the basis of the international convention on the practice of different country, because this law is living law which is associated with the day-to-day life of the Hindus. Therefore, it should be discussed in the light of Hindu law. Therefore, we discuss the concept of source of Hindu law. Source of Hindu law means the sources from where legislature derived these laws. It should be interpreted as per the spirit of those sources. Should not be interpreted in the light of the sources which is outside in India, because this is family law, this is not a commercial law. Pedagogy in approach may be different in a case of commercial law and family law. Family law is rooted. So therefore, we are bound to think over the custom, practices, sastra, and then we are bound to explain the law and that context. So this should be considered primarily. For example, recently Supreme Court declared that wife of the living relationship, partners of the living relationship is entitled to claim permanent alimony under Section 25 of Hindu Marriage Act. Why? Because of international convention and the practices of other country. The question is whether we can think that living relationship is marriage. Term marriage for Hindu is a sacrament, which is explained by Manu, Yagyavalk, Narad, and all the Dharmasastrakar. No one can say that in India marriage is contract or a kind of agreement, a kind of partnership. The purpose of marriage as per the Paraskar Grihasutra is dharma prajaratyartho hi vivaha, means dharma, shan, and sex, three objective of marriage. Therefore, we are thinking about the concept of Ardhanarishwar, Ardhagni, Ardhangini. So how we can thinking that it should be interpreted in the light of international conventions? What is the role of law in society? The role of law in society is norm creation. We should interpret the law for the purpose of creating a norm which is in consonance with Hindu tradition and in consonance with Bharatvarsh, not in the consonance with America. This is the point when we are going to interpret or explain the law. I already discussed in a course about the definition of custom. Under the British law, custom means custom which is observed for a long time. Long time was interpreted in Aylesbury law of England as time out of mind. And time out of mind was explained by them. Time commenced from the King Edward. This interpretation is somehow useful in England, but not in India. In India, the lifespan of human being is 100 years. Therefore, anything which is prior than 100 years will consider ancient. Time out of mind. Without knowing the culture, no one can understand the family law. One may understand the commercial law, corporate company, investment law. It is easier to understand, but family law cannot be understood by without referring, quoting, our tradition. This is the point, and therefore, where the confusion happened, law opened scope for the custom. As I already summarized that section 5 subclass 4 subclass 5 both are subject to custom. Section 7 is subject to custom. Section 29 divorce is also subject to custom. And why this is subject to custom? Because we are the follower of dharma, not religion. Religion is rigid, dharma is inclusive, multidimensional, multifunctional, which already open scope for rational inquiry. And due to rational inquiry, one can do everything. No problem. One student is trying to.
Yes, sir. I admitted him, sir. I admitted, sir.
Okay. This is the point. We should also think about that. The point is very clear and simple. The concept of dharma is holistic. Therefore, under the Hindu law, we have a maximum discretion to interpret the law, accept the view of others. These are the tradition. On that basis, we should interpret and understand the Hindu law. This is my submission. Second, which is relevant under this subject, how I design this subject. Subject is designed in correlation with the Shastric Hindu law and comparison of modern Hindu law. I focused first 2 weeks about the sources of Hindu law, school of Hindu law, and how Hindu jurisprudence developed in Bharat Bhumi is also discussed in the course. Because this is not a secular law, and India Uniform Civil Code is still a dream, not reality. If we are Hindu, we are talking about Hindu law. Why? Because we want to protect the emotion, culture, tradition of the particular community. It should be also reflected when we are going to understand, explain, teach, learn. Everything should be aligned in that objective. Otherwise, you declare that Hindu personal law is no more rational. We will going to adopt Uniform Civil Code, rational law. You are not doing like that. So long as this act exists, it should be interpreted in the light of the spirit which is behind the Hindu law. That's the point. We should be also focused on that. Any other question?
Thank you, sir. Mr. Shivamurthy, do you have any questions? Can you unmute yourself? Mr. Shivamurthy? You can clarify your doubts with sir. We will give you a minute. So he has posted that he does not have any queries, sir. Let me just check on YouTube, sir, whether anybody has posted anything. No, sir, we are not having any viewership on YouTube, sir. So can we end the session, sir?
As you wish. You think
Okay.
that
Yeah,
there is
because students are not there. One student is there, but maybe we can give him Shivamurthy 1 minute in case if he comes up with some query. Mr. Shivamurthy, we are giving you 1 minute. If you have any query, you can post it on the chat box as well. Otherwise, we may wind up the session.
we can.
So actually, I am teaching assistant of this course. So
Oh, okay. I thought you are a student, Shivamurthy. So,
yes,
would you like to add any points related to sir's discussion? Would you like to? Sir discussed a lot of questions raised by the students. Would you like to add any point from your end?
can you could you repeat again what you said? I couldn't.
Yeah, actually, students posted few questions via that Google form. If you open that Google response sheet, you will be able to view all the questions. Do you
Actually,
have
sir,
access to those questions?
no, sir. I have no any question.
Okay. Sir has answered all the queries. I thought of like in case if you have any points you wish to add, no, you can come forward and answer.
If
Anyways,
you want to add some questions, then we can discuss. Otherwise, we are going
Yeah.
to close it.
Yeah, that's all.
I think the point is very clear and simple. The entire course, everything. What I want to add, what the characteristics of this course is. Now the number of PPT slides are there. More than 1100 PPT slides are developed for the purpose of this course. More than 500 pages transcribed materials are also available for the student if they are willing to understand the course. These are the benefits. Number of MCQ questions in the form of assignment, in the form of evaluation is also helpful for the student who participating in the competitive examinations. It is also useful. They have a free resource which is available in this platform. If they have questions, I will respond through email also. My teaching assistant may also respond the same. Things are covered. Now we are completed the 6 month, I hope, and 6 week, and still I have 2 week more. Okay. Thank you.
Yes, coming Friday we will be releasing week 7, and next week we will be releasing week 8, sir. With that, our course will be over, sir. So next month, October 24th, I think examination will be conducted, sir.
When the video of this course available on YouTube?
Like till week 6, it is available, sir.
YouTube.
Yeah, in YouTube also it's available, sir. Yes, sir. So we are
Sir,
uploading the content. Yes, yes, Shivam. Sure.
so
Yeah.
I have some queries regarding the updation of transcription and the class notes.
Mm-hmm.
So it was told to us, we
Mm-hmm.
joined the Google Meet.
Right.
There they told us like it will be uploaded for two purposes. One is transcription, second one is for class notes.
Right.
But learners are not getting that content with
Mm-hmm.
every week. Like I have written mail to NPTL team
Right.
and they uploaded ultimately, but
Mm-hmm.
those lectures in notes format,
Mm-hmm.
uh, they uploaded it simultaneously, 20
Okay.
lectures.
Mm-hmm.
So how a student will go with all those with one time? Because if those content will be uploaded at with every week, then it will
Right.
be more fruitful, I think.
Exactly.
But
Your point is valid, sure.
yes,
So when we release the weekly content, the transcripts should also go. If we are releasing all 8 weeks of contents in one go, it will be very difficult to the students to go
yes.
through the things. It's very difficult. Yes, I agree. So I will make a note of your point and I will inform our team.
So
Um,
the thing is that we are working like three hours for one lecture transcription. Then for the word monolingual word format, it requires around 2 hours to edit. But students are
right.
not getting it. So
Mhm.
the whole effort has no meaning if it
Ye-
will not be circulated to students, learners.
Yeah, agree, Shivamurthy. We will also inform our team to be little active and then try to upload all the things, whatever has been finalized by the instructor on the TE.
Okay, thank you, sir.
Thank you so much. Sir, let me just check on the YouTube for the last time. No post on the YouTube, sir. I think we should wind up, sir.
Thank you. Namaste.
Yeah. Yeah. Thank you so much, sir, for this live session. It was
Thank you.
very informative and helpful. And thank you to the TA as well, Shivamurthy.
Thank you, sir. Thank you,
So
sir.
we are closing the session now. Thank you all.